Hello, and thank you for allowing us to assist you in marketing and selling your property. The first official step in this process is the execution of the listing agreement between you and Realtors, our licensed Illinois real estate brokerage. The following presentation summarizes the major points of this document. In addition, our agents will be happy to answer any questions you may have, so please feel free to contact us by calling 847-954-2200, emailing us at ateam@realtors.com, visiting our website realtors.com, or contacting your designated agent directly. As members of the Mainstreet organization of Realtors, we use its residential exclusive right to sell marketing agreement. This is the standard listing contract most commonly used across Chicagoland, along with the Chicago Association of Realtors version. In this presentation, when we say listing agreement, we are referring to that Mainstreet form, the agreement we use to represent you in selling your property. In this presentation, we may refer to our associate brokers, who are all members of the Mainstreet organization of Realtors, as agents. The top of the first page of the listing agreement lists all the parties involved. This includes Realtors, the managing broker of Realtors, the designated agent, who is a member of Realtors' A-team, and you, the seller. Section 1 provides information about the property, including the address and property index number for property tax purposes. It also allows to add information about any parking or storage spaces, which may be applicable to condominiums or townhomes. Section 2 specifies the length of the agreement, including the start and end dates. It also includes a non-discrimination clause, which must be initialed and strictly followed. Under Illinois law, it is illegal to discriminate in the sale of real estate based on race, age, color, religion, sex, ancestry, order of protection status, gender identity, marital status, physical or mental disability, familial status, pregnancy, national origin, sexual orientation, military status, dishonorable discharge from the military service, arrest record, or any other class protected by the Illinois Human Rights Act. Section 3 sets the marketing price or asking price for your property. The price is determined by you, the seller, in consultation with us, with the goal of maximizing your net proceeds. Factors considered include recent sales in your area, current market trends, timing, and your individual needs and preferences. During our consultation, we will discuss different pricing strategies, including apparent market value pricing based on recent sales and likely appraisal value of your property. Aspirational pricing, which is set above the apparent market value to allow room to negotiate, but the concern may be the appraisal if the property sold at this aspirational price. Below market pricing, normally set to attract more interest and multiple offers, potentially driving the final price higher. Ultimately, the final decision on the marketing price is made by you, the seller. Section 4 states that possession is to be negotiated at the time of the contract. The default understanding is that you will vacate the property prior to the closing and will transfer possession at the time of closing. If you intend to retain possession of the property for any period after the closing, it is critical for you to make these post-closing provisions part of the initial contract negotiations or, at the latest, during the attorney review. Section 5 covers the home warranty, which you may offer to buyers at your expense. A home warranty can help reassure buyers about the condition of older appliances or systems that may be nearing the end of their expected life. Ask your agent about the different home warranty programs that are available. Section 6 identifies your designated agent, a member of our A-team who will work directly with you throughout the sale. Section 7 requires that you identify which personal property will be included in the sale, such as your appliances. It also allows to insert any personal property items to be transferred to the buyer, but which are not specifically listed to be checked off. Additionally, there is extra space to insert any items that are specifically excluded from the sale. Another important point about this section is that it allows you to specify any personal property that is not in operating condition. This section closely aligns with the personal property section of the Multi-Board Residential Real Estate Contract version 8, which we cover in our contract presentation and to which we will refer to in the remainder of this presentation as the contract. Unless the contract is subject to the as-is provision, you warrant to the buyer that all personal property included in the sale will be in operating condition at closing, unless otherwise specified in the contract. Section 8 requires you to disclose any alternative energy systems at the property, such as solar panels, and provide details about any related contracts. Its content closely aligns with paragraph 34 of the contract. Section 9. Dual agency occurs when a designated agent represents both you and the buyer in the same transaction. Realty and the A-Team generally do not allow dual agency and typically exclude this section from their listing agreements. Section 10 outlines your duties as the seller under the listing agreement. Please review this section carefully and contact us if you feel you may not be able or willing to perform any of the specified duties. Section 11 gives you a choice to allow or prohibit buyers and their agents from filming or taking additional photos of your property. We recommend prohibiting such activity to protect your privacy. This section also addresses offer letters from buyers. We advise that you do not accept any offer letters, as accepting such letters may create a risk of discrimination claims. Section 12 contains a disclosure that Realty also represents buyers in real estate transactions, and, when we do so, we enter into representation agreements with those buyers and designate certain agents, including members of the A-Team, as buyers' representatives for showing the properties listed with Realty or other brokerages and negotiating their purchase. Sections 13 through 15 outline your acknowledgments and consents regarding Realty and A-Team agents. They cover our representation of other sellers and various buyers, as well as the duty of confidentiality we owe to buyers that were previously represented by our agents and who may now be interested in your property. Section 16 specifies the compensation of Realty for its services, which may be expressed as a percentage of the sale price, a fixed amount, or as otherwise mutually agreed. It may also provide for additional compensation, including in transactions where the buyer is not represented by a licensed real estate broker. This section further establishes a protection period after the expiration of the listing agreement. If your property is sold during that period to a prospect who received listing information during the term of the agreement, commission may still be payable to Realty. Compensation is generally payable by you to Realty at closing upon a successful sale. However, commission may also be due if a transaction does not close because your refusal, failure, or inability to perform under the terms of this agreement. Realty may, at its sole and absolute discretion, extend offers of special discounted pricing to sellers who agree to use the services of our title agent affiliate in connection with the sale of their property. This approach reflects Realty's integrated service model, which coordinates the efforts of our affiliates and partners, including our real estate brokerage, title company, law firm, and mortgage brokerage, to provide quality services at a competitive overall cost. If special discounted pricing is offered, an addendum to the listing agreement will specify the amount of compensation payable to Realty if you elect to use our title agent affiliate in the sale of your property. If you use our title agent affiliate, compensation is the amount stated in the addendum. If you do not use our title agent affiliate, compensation is the amount stated in Section 16 of the listing agreement, not the addendum. Criteria that may influence whether discounted pricing is offered by Realty include, without limitation, the approximate value of the property, proximity of the property to our offices and our agents' operating areas, current volume of transactions and our agents' availability, capacity of our title agent affiliate, and general market conditions. Ultimately, while Realty may offer discounted pricing, you, as the seller, always retain the sole and absolute discretion to decide whether to use our affiliated title agent services. Section 17 specifies whether you authorize Realty to indicate that you are willing to compensate the buyer's brokerage for bringing a buyer to the transaction. Such compensation, if offered, is payable to the buyer's brokerage at closing once the transaction successfully closes, except in cases where you fail to perform under the terms of this agreement, which may result in a claim for compensation by the buyer's brokerage. All commission paid to the buyer's broker is negotiable. You are not required to offer any compensation, but many sellers do so to increase their chances of attracting a buyer and closing within a reasonable time frame. If you choose not to offer compensation, buyers will have to pay their broker directly. Since buyers already face substantial costs such as loan expenses, title charges, attorney's fees, and other closing costs, requiring them to also cover their broker's commission may make the purchase unaffordable, even for otherwise qualified buyers. For this reason, many sellers choose to pay some or all of the buyer's broker commission and adjust their asking price accordingly. However, in cases where the property is likely to attract cash buyers or buyers with significant funds, you may choose not to offer any compensation to the buyer's broker. In the greater Chicagoland area, the customary seller-paid compensation to buyers' brokerages has historically been around 2.5% of the sale price. The decision whether to offer compensation and in what amount is entirely yours. Section 19 outlines the means and scope of marketing services under the listing agreement, which are generally conducted at the discretion of Realty and its agents. Section 20 addresses the display of your property's listing on the internet, which we strongly recommend due to the importance of online marketing. We recommend to choose the following in this section. You authorize the listing to be displayed online. You authorize the property address to be displayed online. You do not permit comments or reviews on the listing. You do not allow any automated estimate of value on the listing. Section 21. Most residential contracts in the greater Chicagoland area require the seller to obtain a title report from a licensed Illinois title company, provide title insurance for the buyer, and furnish a plat of survey, all at the seller's expense. Costs vary with the sale price, as both the title company's closing fee and the title insurance premium increase with higher prices. Overall, title and survey costs typically total several $1,000s. We provide all our sellers with approximate closing costs up front, including title and survey fees, broker's commissions, property tax credits, transfer stamps, attorney's fees, and other expected transaction costs. These are estimates based on certain assumptions such as the sale price, tax proration, and closing date, but they still provide useful approximation of the total expected closing costs. If the listing agreement includes special discounted pricing based on your agreement to use our title agent affiliate, our affiliate's name will be inserted in the listing agreement, line 262, along with the terms outlined in the addendum referenced in Section 17. Section 22 corresponds to paragraph 24 of the contract, which we review in our contract presentation provided to you with this listing agreement presentation. It is essential that you carefully review these representations to ensure they are true, accurate, and complete as they relate to you and your property. If any representation is not fully accurate, it must be addressed during initial contract negotiations, through a contract modification or addendum, or at the latest during the attorney review. Additionally, it is critical to complete all applicable disclosures truthfully, including the Residential Real Property Disclosure Report, the disclosure of information on radon hazards, and the lead-based paint disclosure. Providing false or incomplete information, whether intentional or inadvertent, may expose you to legal liability to the buyer. Section 23 identifies services that are outside the scope of the listing agreement and will not be provided by Realty. Section 24 outlines the minimum services that Realty is required to and will provide under the listing agreement. Section 25 requires you to provide accurate information regarding property taxes, association assessments, and any special service area assessments affecting the property. For more details, refer to our presentation on the contract provided to you with this listing agreement presentation. Section 26. Realty does not hold the earnest money. In transactions where you choose to use our affiliated real estate attorney or our affiliated title agent, the earnest money will be held by the affiliated title company at no additional charge. For further discussion about the earnest money, refer to our presentation on the contract provided to you with this listing agreement presentation. Section 29 requires you to indemnify Realty and its managing broker in the event you fail to perform under the listing agreement, or if any liability arises from misstatements or misinformation that you provided. It is absolutely critical that all information provided in the listing agreement and for marketing your property be true, accurate, and complete in all respects. Sections 27, 28, and 31 to 36. These sections contain general contractual terms that are not specific to the listing agreement or real estate transactions. They are standard contractual provisions and should be self-explanatory. This presentation is not a comprehensive discussion of the entire listing agreement. Its purpose is to highlight the most important terms of the listing agreement that are most consequential to you, the seller. It is not a substitute for reading the entire listing agreement. Rather, it is intended to supplement your review of the entire listing agreement form. If you have any questions about this presentation or the terms of the listing agreement, please contact us by calling 847-954-2200, emailing us at ateam@realty.com, or reaching out directly to your Realty A-Team member.